Okay, so there are 7 steps that I see if I were the attorney and I had to make out a case of felony murder for Hunter Metcalf, for the death of his brother Austin Metcalf at the hands of Carmelo Anthony. These are the steps that I would take to get there. Nobody is talking about this. Okay, so the doctrine that I'm talking about is the felony murder doctrine, which in Texas comes out of the criminal homicide statute, right? It is a particular application of the criminal homicide statute, okay? And basically what the felony murder doctrine says is that if 2 or more people commit a felony and a death happens in the course of committing that felony, everybody involved can be liable for that death, regardless of whether it was intended, regardless of whether they're the one who actually did the killing. And this is what's really interesting, one of the felons or one of the perpetrators could be the one who gets killed, right? So this is the example where 2 people decide that they're going to go into a convenience store, they're going to rob the convenience store, and either one of the 2 people kills the store clerk, the other one is also liable for that murder. But here's the flip side that's more analogous to the case we're talking about here. In this case, it's more like 2 people go to rob a convenience store and the store clerk shoots and kills one of the attackers. The other attacker is liable for the death of his partner, his co-felon. Okay, so that's the analogy that I'm making here, and I believe that I can make this out, and I will tell you exactly the strategy that I would use if I had to prosecute this case. So another thing to keep in mind here is that in this case, the defendant is Hunter. Okay, so the case I'm about to make out, the defendant is Hunter. He would be being accused of being a co-felon of his slain brother. All right, so let's get into it. In order to establish the felony murder doctrine, we'd have to establish that Austin and Hunter committed or attempted, that's important, or attempted a felony. In this case, the felony that I'm going to make out is felony assault. And during the commission of that felony, Austin was killed. Therefore, I'm about to argue, Hunter is guilty of murder as a co-felon under the felony murder doctrine. All right, bear with me. So in order to make this out, the first thing we have to establish is that there was an assault. At this point, we don't even have to make out that it was a felony assault. All we have to do is make out that they committed an assault. And when I say they, either of them, when they were doing this act together. Now, a lot of people have said, the police statements have said, witness interviews that have come out, and there's been a witness on Carmelo's side, and there's been a witness also on Austin's side. They gave different versions of the events, but they all confirmed, including the words of Hunter himself when he was talking to the media, that they initiated the exchange and also initiated the physical contact. Okay, separate and apart from whatever Carmelo did. We'll get to that in a minute. They initiated the exchange by walking up to him, and they initiated the first contact, whether it was a shove, whether it was a push, whether it was a punch. One witness said that the 2 of them jumped Carmelo, right? We still have to wait for the evidence to come out. But what is clear is that there was some type of an assault. And that happened the minute that Austin touched, shoved, or punched Carmelo. God forbid he kicked or anything else that the one particular witness is saying, okay? All of this is confirmed. So I think everyone is in agreement about that. What people are not in agreement about is what that meant. All right, so, sorry. Okay, so a simple assault can be elevated to an aggravated assault or a felony assault if the actor, the assaulter, picked up something or used a weapon or some kind of an enhancement or something like that. Okay, so let's see what happened. If in the course of a simple assault, which is what a fist fight would be, your basic average fist fight, 2 guys fighting in a bar, some road rage or something like that, that's going to be your basic assault. until one of them picks up a force multiplier. Okay. A force multiplier is a deadly weapon. Okay. Now, a lot of people, when they think of deadly weapons, they think of the usual things. And we're going to see a list in a minute, but like the guns, the cars, things like that. But Texas has said that there's a lot of things that can be deemed deadly weapons, and that a deadly weapon in Texas, it's not about what is used. It's about how it is used. It's not the what, it's the how. And what you're going to see in this list in a minute is that all kinds of things have been deemed deadly weapons in Texas, right? So my argument says that a second human is the equivalent of a weapon when the force is coordinated and overpowering. So what does that mean? If I want to hurt you, I could pick up a pipe. I could run you over with my car. I could pick up a gun. I could pick up a pipe, or I could bring my twin brother. And my twin brother becomes the force multiplier. My twin brother makes it so that I can do more harm to you than I would have done without it, right? That's what a gun does. That's what a knife does. That's what nunchucks do. They allow me to cause more harm to you, which is why I picked it up, right? They allow me to cause more harm to you than I could on my own. My brother is the thing that I showed up with that would allow me to do more harm to you than I could do on my own. Okay, so let's get into this because this is supported by statute and it is supported by Texas common law. Okay, so when we're talking about deadly weapons, and the reason we're talking about deadly weapons here is because we're talking about what makes an otherwise simple or misdemeanor level assault, what elevates it into a felony, into felony assault. Felony assault is necessary to establish the felony murder down the road. Okay, so here are the usual suspects: guns, knives, vehicles, cars, trucks, whatever, pipes, metal bars, a baseball bat, a broken bottle, right? I'll cut you. These are sort of the things that we know and expect to be considered deadly weapons. But Texas has also found a ton of other things to be deadly weapons that don't count as the assailant or the attacker being armed, right? So a lot of people are saying that you can't pull out a knife and cut somebody if they're unarmed. Texas law has shown time and time again that is not the case. I think I have here about 8 or 9. There are many, many others according to Texas law. Right now, Texas law is a fairly broad law, which means that it captures a lot of behavior in their statutes, right? That's what sort of law and order states tend to do. But let's look at some of these things that Texas has decided are deadly weapons, not based on what they are, but based on how they are used, okay? Body parts, an elbow, the elbow of the person, right? He didn't pick anything up. He used his elbow in such a way and on such a person that Texas said that counts as a deadly weapon. Shod feet. All that means is that it's your foot with a shoe on it. So if you kick somebody, you stomp somebody, the courts in Texas have found that a shod foot specifically, a foot with a shoe on it specifically, is a deadly weapon. Also a dog. You tell your dog, go get him, sick him, right? Sick him, puto, whatever, whatever. Concrete sidewalks, right? So you don't even have to pick anything up in Texas for it to be a deadly weapon. And the thing about it is once the court decides that these things are deadly weapons, it elevates an assault into a felony assault, and that opens up a ton of other consequences, okay? Concrete sidewalks. You get into a fight and you bang someone's head against it. How big of a jump would it be to say a bench, a tree, right? A pillow? Texas has said that a pillow is a deadly weapon. And what happens is if you use a deadly weapon against somebody, they are entitled to use self-defense against you. And if we're talking about smothering somebody, any of these things can lead to death. That's why they're called deadly weapons, which means that the self-defender can retaliate with death, can respond with death, right? So if someone appears to be smothering you with a pillow, as was the case in Dawson v. State, you absolutely can pull out a knife or a gun and shoot that person in self-defense. The court has said it's okay. A beer bottle, this is kind of obvious. You break a beer bottle, you hit somebody over the head, you slice their neck, whatever. A telephone cord, a simple telephone cord that we all have lying around the house, it's a deadly weapon. If you can use it outside to do jump rope, or you can tie something up with it, or you can use it in this fashion, which the court has said is a deadly weapon. And if someone comes after you with a deadly weapon, and this is interesting, we're going to get to this. Even if they haven't done the thing yet, if someone is chasing you with a cord, if you think they're about to take that cord and strangle you with it, you absolutely can use deadly force in response. Pens and pencils, if they're used to stab somebody, right? Kids stab each other all the time with pencils, but in the right scenario, it can be a deadly threat warranting a deadly response. Now, the bottom one is the one that maybe is most applicable here. Your hands and fists when used with overwhelming force. Now, remember that I said that the 2-on-1 elevates the threat. This is why. Because now instead of 2 fists swinging in your direction, you've now got 4 fists swinging in your direction. And this is the case of Lane v. State. And I think this was a domestic violence case where the husband was beating his wife, and the court said that his fists were rightfully perceived as deadly weapons. Okay, so this idea that you have that your attacker has to be armed is just not true. It is just false, and people should let that go because it's blinding people to what's really going on in this case. Okay, so here's the argument that I alluded to earlier, but I'm going to make the argument out here. Because we just established that there are a lot of force multipliers that a person could use against their potential victim that would warrant self-defense by the victim. Okay, so the argument you've heard me make is that when Austin and Hunter showed up together, and it really doesn't matter which of them was the main aggressor, right? There's question about that, right? Not every version of what happened aligned with Hunter's version. Hunter's version was that his brother alone did this crime. Doesn't matter which one of them did it. 2-on-1 force is this, right? 2-on-1, 2 guys beating up 1 guy or threatening 1 guy is the same thing as 1 guy threatening you with a knife or a gun. The statute and the common law in Texas has shown that. So the fact that there's 2-on-1, 1 guy with a force multiplier, his brother, elevates it. So now we've got the aggravated assault. We've got the felony assault that we need to make out felony murder. Done. Okay. That also takes it out of the realm of a simple fist fight, and the presence of the twin, the involvement of the twin, functionally that served as legally the same thing as having a deadly weapon. Okay, so one of the other things that people are saying is that, well, this was a simple dispute between kids. This was an immature. I saw one YouTuber, he described it as this is an immature something or other. No. Witnesses say, and there was a witness who came out, V. Kaylee M. She, I'm not sure if she was a witness, but she was a representative of the witnesses, I'll say. Even she acknowledged that they approached him, and within 5 seconds, they had already laid hands on him. She said in less than 5 seconds of approaching him, they had already laid hands on him. There's another witness that says that he was there with his 2 daughters, and he watched the 2 boys jump Carmelo. He said that Carmelo was sitting down, looking at his phone, reading his phone or something, and the 2 boys just started in on him, right? So this was not just a mutual fight, because a mutual fight is a defense to assault. What a mutual fight requires, or what a mutual fight requires, that there's some kind of an agreement that this is where this thing is about to go, or God forbid they say, okay, let's meet outside the bar and let's fight it out in the parking lot. and then one guy ends up getting the better of the other guy, he can't then scream that he was assaulted because he agreed to meet in the parking lot and have the fight, right? The fact that it was unexpected, right? And both witnesses say, the girl said, Austin's friend, she said that within 5 minutes, her name is V. Kaylee M. She said within 5 seconds, they had already started touching this kid or punching him or pushing him or whatever they did. The other guy said that he was not paying attention. He was reading his phone and he was jumped, right? So this was an unexpected attack based on those two statements. This was an unexpected attack on Carmelo. So there was no mutual combat. Now, also, and we're going to get to this, a surprise attack is one justification for self-defense. You can't do a blitz attack and then expect that person to have perfect clarity and be able to perfectly assess what's going on. That's what a blitz attack does, right? 5 seconds sounds like a blitz attack. Okay, so the other thing that I want to get into, now that we've established that there was a felony level assault by virtue of having the second brother there, which the witnesses have both said on both sides, I want to get into the self-defense, okay? And I want to do self-defense 202 because everybody online is doing self-defense 101, which is, this is self-defense 101. You can't hurt somebody that's not armed. That's false. You have to meet the force with force. That is also false, right? Or I won't say that these are false. I will say that there are lots of exceptions and lots of work that the common law has done to shape the contours of what these phrases mean. So we're going to get into self-defense law 202. 201, I mean. Okay. It says that deadly force is allowed if there's a threat of serious harm. It does not say that the harm has to have happened. You just have to have a reasonable threat. And the argument that I would make is that if it's true that what the police report says, that Carmelo Anthony is 130 pounds, if he had potentially 450 pounds coming in his direction, right? Because there's also this idea that the two boys were each about 220, somewhere between 220 and 230 pounds each, right? So Carmelo is 130 pounds, and this will all come out, but that's what the police report says. And he was confronted with 450 pounds of a threat, right? So if there's the threat of serious harm, and if I weighed 130 pounds and I was confronted by 450 pounds, I would think that I'm in danger, okay? Also, there is no duty to retreat. A self-defender does not have to retreat. It might be wise. You might recommend it. You might personally at least try. I think I would try, but he's not legally required to, right? And we have seen this exact issue in Castle Doctrine, stand your ground, right? We have seen this litigated in the courts so many times that we know that he doesn't have a duty to retreat, whether he's at home or whether he's in public, okay? The next piece of self-defense is this idea. People keep saying, well, he didn't have a right to be under the tent. That is not true. They had, the people who managed that tent, whoever they were, the team, the school, I don't know, they had no legal right to exclude him from that tent or from that bench at all. Now, it may have been customary, it may have been courteous to not be under another team's tent, but there is no legal right to exclude off of public grounds, right? And I want you to play this out to its full conclusion. Let's say, okay, let's say that that such a rule did exist, that someone could just put up a tent on public property and then exclude everybody from in it, except the people that they decided could go under their tent or their hut or whatever it is. Where does that stop? What if I tripled the size of the tent? What if I built something that took up 50% of the park? Could I just say, hey, this is my tent, nobody has a right to be there? No, you can't do that. You can't do that, right? And here's another thing, and I'm going to talk about the lawsuits that are about to fly back and forth. If they try to make the argument that they somehow had the right to exclude from this area. Here's the thing. The right to exclude also comes with liability for things that happen in the area that you have the right to exclude people from. So if they say that whatever the square footage is, whatever the footprint of this tent is, we have the legal right to exclude people from it, then they are liable for other things, right? They are liable for what happens in that area because they are the de facto, or not de facto, but they are the constructive owners of that space. So they're going to have to tread very lightly about this. Either we control this space, right? And with control comes responsibility under the law. With control comes liability under the law. They're either going to say we control this space and have the right to exclude, and that still probably is not even a legal right to excuse. Like I said, it might be customary or courteous or whatever, but so either they say, yes, we had the right to exclude, therefore we're liable for anything that happens in here, or we didn't have the right to exclude, which they did not, and therefore they're not liable. Okay, so the next thing is, and V means the victim in this case, right? The victim warned them before acting. So a lot has been made about what Carmelo meant when he said, touch me and see what happens. Some people say it was a warning. Some people say it was a provocation. It can't have been a provocation in an incident that was initiated by the other people. It was a warning. It was a warning. If you keep doing this, something is going to happen in response. And that is exactly what happened. But they had already initiated the thing that he was responding to. Okay. And then the other thing, and this is important, right? Because some people say, oh, it was just a shove. No, he just grabbed his backpack. No, he just did this. No, no, no. Self-defense, right? The perception of a serious harm can exist even before the first punch, right? So for example, you don't have to wait to be harmed or immobilized or disabled or taken out, right? We know about one punch kills. They're becoming more common, right? You don't have to wait for the other person to immobilize you with the first blow before you are entitled to defend. Because if you did, right, let's say you had to wait for, several blows before you decided you're in danger. Well, you could be dead by that point, okay? And if you guys remember, if you watched the, what's that guy? The George Zimmerman case. If you watch the George Zimmerman case, you will remember that the firearms instructor was on the witness stand. And the lawyer said to him, should a defender wait until they've been injured to pull out and use their firearm? And this guy, this firearms defender, I want to say he was a naval guy, but I don't remember, or had been in the Navy. But anyway, he was a firearms instructor. And he said, oh, no, I don't recommend that. And the whole courtroom laughed. You may remember this, right? So he was basically saying, no, it is not smart to wait until you're injured, or until the person is right up on you, or until, right, and until you're laid out on the floor. That's not smart. All right. So there is nothing here that waives the right to self-defense. We've already established that he was the victim of a felony assault. We've already established that there were two actors on one, based on not what Hunter said, but what the witnesses said, even Austin's witness, right? The witness that said that they both touched Carmelo also called herself a good friend of Austin. Okay, so you guys remember, this is my channel is called Counsel Gray. Thank you for being here. If you would, I'd appreciate the support. Like, share, subscribe, hit the bell notification, and leave a comment. I will, as soon as I figure out how to respond to comments while I'm going live, I will start doing that. But I will respond to all reasonable comments. Okay, so Hunter can still be charged. Just because he hasn't been charged yet doesn't mean that he cannot be charged. And the fact that Carmelo's bail was reduced today could show that more has come out that reduced the likelihood of a full-on sentence or a full conviction. That oftentimes when judges reduce sentences, it's because there's more clarity about what actually happened in the event. Okay, so I want to draw something else to your attention. How easily it can be found that two people agree to act in concert. Okay, so he acted jointly with Austin. Now let me back up and say this. This is how I would make out the case in court if these things turned out to be true, if these witness statements become corroborated. The police reports that everybody read, they also are not corroborated, right? I think we read the reports of maybe, I don't know, 4 to 6 officers in that one police report. All of that stuff is hearsay, and it's hearsay within hearsay. But the detectives, after that sort of initial set of police reports, right, because they're writing their reports about what happened on the scene. After that, the next step in the process is that detectives go out and figure out what actually happened, and they corroborate things and things like that. So I am spelling out, if these things come to be true, this case is still available. This charge is still available. Okay, so how does the agreement come about? Okay, because part of the felony murder is that these two acted jointly, that there was some agreement to do a thing. Not just that two people were doing two separate things simultaneously. That is not the agreement that's required. The agreement that's required is that these 2 people or 3 people or this group or gang or whatever it is, that they had one shared mission. Okay, so something as simple as, all right, man, I got your back. That's agreement. Now, the law and the case law have also shown that the agreement doesn't have to be spoken out loud. It can be tacit. It can tacit meaning unspoken, or understood, right? It can be based on the pattern of the people, that when we do things like this, we're in it together, right? 2 twin brothers who grew up defending each other, absolutely, there's a tacit agreement that if one of us is in it, we're all in it, okay? So I got your back, brother, spoken or unspoken, leads to the agreement required for felony murder. Or something as simple as, come on, let's go get him out of here. And then the 2 of them walk over and start this altercation, right? So the law of parties, right? When there's a party of people doing a thing, they have joint liability for the consequences of the thing. And as I said earlier, it doesn't matter who caused the fatal wound. Now, this is the interesting part. Remember the example I gave you in the beginning. It doesn't matter whether the slain person was one of the attackers, right? One of the group, or if it was the victim. It doesn't matter who died, and it doesn't matter who killed them. The victim could kill one of the attackers, or one of the attackers could kill the victim. It doesn't matter. Everybody in that party is jointly liable for the death. Okay, so an example of that, and we've seen a bunch of examples of this. So the sort of classic example is the one I gave you earlier. They go in to rob a store. The store clerk shoots one of them, right? You know, the store clerk shoots one guy. The homie is responsible for that. Or vice versa. They both go in to rob a store. The other guy shoots the store clerk. They're both liable for that murder. Another place that you may have seen this is 2 guys steal a car, and they get into a police chase, and the driver crashes the car, and his passenger dies. The driver is not just guilty of stealing the car and outrunning the police and all that, you know, running red lights, but is also, right, the driver is also liable for the death of his girlfriend or the death of his homie in the passenger seat. Okay, so it doesn't matter who caused the fatal wound. It also doesn't matter how it happened. It could be a gun, it could be a knife, it could be getting crushed. It could be dying in a car crash. It doesn't matter. Okay, so I have basically just made out felony murder. It was a joint felony, right? The presence of the second brother aggravated a simple assault into a felony assault. The death happened during the attack. Austin was killed. Self-defense still stands because it hasn't been removed based on what we just walked through. So that makes it murder, even if it was unintended. So for that reason, Hunter Metcalf, if these facts continue to unfold the way they are unfolding, this kid is liable for the murder of his own brother. Okay, so now in addition to the felony murder that I just made out, there is another enhancing doctrine called the EOCA doctrine, engaging in organized criminal activity. This is a doozy because what this statute says is that if a felony is committed as a part of a combination, now the statute defines combination as 3 or more, etc., but the common law has repeatedly defined it as 2 or more. And it says they don't have to be in an organized gang, right? Like they don't have to be, you know, MS-13 or Crips or Bloods or, you know, whatever the gangs are. They don't both have to be in that. The fact that 2 people acted in concert is enough to activate this enhancement on the behavior, right? So this is a sentencing enhancement. It also can serve as an alternate predicate felony. I'm not going to get into that, but this is sort of the second path to get to liability for Hunter. And again, the twins acted in concert. Remember when I said earlier that it's not enough that they did 2 things simultaneously? They had to both be doing the same thing, and they were, right? So their joint assault equals organized criminal activity. Now, this is designed to, I think the origin of the statute was probably to deal with what sort of traditional organized crime and really street gangs. However, the use of it has extended outside of that, and I believe that it could have applicability in this situation. We will see. Okay, so to me, that is the path to felony murder for Hunter. If the facts continue to unfold the way it's looking like they're going to unfold, then Hunter could be in serious trouble. Now, let me say this. Felony murder falls apart if 2 things don't hold up. If the simple assault does not get aggravated to a felony, because felony murder only attaches when the underlying act was a felony. Okay, so let's say he were to get charged with this, right? And based on what I saw of the prosecutor today, it's not likely that he's going to get charged with it. But let's say he does get charged with this. Those would be his 2 outs. The first one would be, this was a simple assault, not a felony assault, and the presence of another person does not equate to a force multiplier. I don't think that's going to work. The second way that Hunter would escape this is if the self-defense falls apart. And I don't see how he's going to make that fall apart, because you also have to remember that self-defense is made out in the eyes of the reasonable eyes of the victim. Okay. And if you just look at a 130-pound rock and a 450-pound rock, which one is going to smash the other one into pieces? Right. So I don't know. This is what I think. This is my theory. Okay, so again, this is Gray. My channel is called Counsel Gray.